rise.
The Kosovo Specialist Chambers is now in session.
Please be seated. Good morning and welcome everyone. Court officer, could you please call the case?
Good morning, Your Honors. This is file KSC-BC 2023-10, the Specialist Prosecutor versus Sabit Januzi, Ismet Bahtijari, and H.Shala.
Thank you. Now, I would kindly ask the parties and the participants to introduce themselves, starting with the Specialist Prosecutor's Office. Mr. Prosecutor, you have the floor.
Good morning, Your Honor. Thank you. Joshua Hafetz on behalf of the Specialist Prosecutor's Office, and I'm joined by my colleagues today. Specialist Prosecutor Kimberly West, seated behind me. To my left, Associate Prosecutor John Devaney, and case managers Lena Peterson and Anna Goboldov. Thank you.
Thank you. Very well. Now, the Registry, Deputy Registrar, you have the floor.
Thank you. Good morning, Your Honors, and good morning, colleagues. Jonas Nilsson, Deputy Registrar. I'm here with Whitney Price, Legal Counsel, representing Registry today. Thank you.
Thank you. Now, I turn to the defense. And could you kindly add to your introduction, who of your team is participating remotely or is present in the courtroom, and likewise for your client, because today we have a kind of a hybrid court. We will start with the defense for Mr. H.Shala.
Good morning, Your Honour. Toby Cadman, Specialist Counsel for Mr. H.Shala, who is in the courtroom with us. All of our team are present in the courtroom. None of our team is appearing remotely. Mr. John Cubban to my left is Specialist Co-Counsel. Behind me, Ms. Isabella Kiwan, Legal Associate. And to the far end, Mr. Admir Barisha, Investigator.
Very well. Now I turn to the defense for Mr. Bahtijari. And who will be taking the floor? Lead counsel?
Yes, it's Felicity Gerry here, Specialist Counsel for Mr. Bahtijari. Co-counsel Ms. Karin is in person in court. Also online with me are Philippa Stafford and Katie Delaney, who are administrative assistants merely observing today, and Cassandra Lagood, who is an intern merely observing today. And I should have said good morning, Madam President, and good morning to everyone in the courtroom. Thank you.
Thank you. Now I turn to the defense for Mr. Januzi. You have the floor.
Your Honour, my name is Jonathan S. Rees, King's Counsel. I appear remotely on behalf of Mr. Januzi today. I'm joined by co-counsel Mr. Hugh Bowden. He is also joining remotely, as is Mr. Januzi, who is in the DMU.
Thank you. That's all noted. Mr. H.Shala. Yeah? No, please, you can remain seated, Mr. H.Shala. Mr. Bahtijari, remotely in the video connection, and Mr. Januzi, I remind you that all rights under the law and the rules, as they were read to you by the pre-trial judge during the first appearance, continue to apply before this trial pending, including your right to remain silent. Very well. My colleagues for trial panel 1 are Judge Ronald Dekkers, Judge Gilbert Biti, and Judge Vladimir Mikula, Reserve Judge, and I am Mappiveld Folia, Presiding Judge for trial panel 1. I will give a short procedural history to introduce today's hearing. On the 4th of September 2024, the pre-trial judge transmitted the case file to the trial panel 1, assigned by the President of the Kosovo Specialist Chambers for this case. On the 24th of September, the panel issued a decision scheduling trial preparation conferences on the 7th, the 8th, and the 9th, and, if necessary, on 10 and 11 October of this year. In the same decision, the panel requested the parties and the registry to file written submissions on a number of issues, with a view to gathering all relevant information to plan the next steps for the start of this trial. We received your submissions on the 1st and the 2nd of October. And so the purpose of this week's hearing is the expeditious preparation of the trial as foreseen in the Rules of Procedure and Evidence. And we will do that together with the SPO, with the defense and the units of the registry. The intention is to gather further submissions in addition to the written ones already received on any issue that needs to be resolved in order to be able to start the trial, if possible, in November 2024. And given the limited scope of the case, the limited evidentiary records, and the steady progress of the case from the pre-trial to its transfer to the panel, and considering that 3 accused are in detention since October and December of last year, the panel expects the parties to be trial ready in the very near future. This panel has an obligation to efficiently manage the proceedings to ensure a fair and expeditious trial. And the panel will take the necessary steps to do so, and we expect the full collaboration of all parties and the registry. Regarding the scope of this week's hearing, I trust it's clear that today we will not discuss the guilt or innocence of the accused, and that we will not examine the evidence. Okay, our schedule for the upcoming days. I recall the schedule as foreseen in our decision scheduling the trial preparation conference, filing 479, paragraph 11. We will kick off today with 4 sessions of 1.5 hours. We have 1 hour break at 1 o'clock till 2. And this schedule, if needed, we will follow that also on Tuesday and Wednesday. And by using 4 sessions a day, we maximize the possibility that all specialist counsels can attend as much as possible of the trial preparation conference. Okay. Agenda is as follows. First, we will invite the parties and the registry to present their further submissions about the items on the agenda. I will address each of them individually, and please don't repeat any submissions that has already been submitted in writing, and kindly present your further submissions in the order I will address them, in order to keep everything so organized as possible. Secondly, I will address some additional issues that came up last week. Thirdly, you will be given the possibility, both parties and the registry, to raise any other points that are not on the agenda in the decision scheduling the trial preparation conferences, and kindly save your additional points for that moment. And finally, we will issue a number of oral orders, and we will inform you of the decisions this panel intends to take in the upcoming period. And these oral orders will certainly not be issued today. Very well. I remind the parties and the registry to give the panel prior notice should any submission require the disclosure of confidential information. We can in that way go into private or closed session. We have people participating in the courtroom and via video conference. And please only take the floor when I have explicitly given you the floor. People talking over each other results in a record of the hearing that is incomplete and unclear, and it does not allow to understand each other. And that is the main purpose, of one of the main purposes of today's hearing. If the people participating via video conference would like to be given the floor, and I will be giving you the floor very often today to hear further submissions, but if there would be an additional moment, please raise the icon of the hand, and then I will give you the floor. Very well, then we will start with the first point on the agenda. Those are the investigations and disclosure of evidence. We instructed the Specialist Prosecutor's Office to confirm whether its investigations and the disclosure of incriminating evidence in this case have been completed. Mr. Prosecutor, we have noted your submissions as to the disclosure of this further incriminating evidence, and I will give a short summary, and I will not be doing that with all the submissions given to us, but for the purpose of this topic, I think it's important. We noted, Mr. Prosecutor, that the SPO will shortly file a request to the panel to add a number of items to its exhibit list. Then there are some items that are not yet in the possession of the SPO that will be disclosed and added to that same exhibit list as already authorized by the pretrial judge. And thirdly, there has been a review of the disclosed items, and that has led to some additional disclosures in the last month. Yeah, I see you nodding. And the SPO does not currently anticipate any further disclosures beyond those mentioned. Very well. We have some further questions. We seek submissions from the SPO as to what extent any of the recent disclosures in September, after the case was transferred to trial, contains new information not previously disclosed to the defense, as opposed to new versions or translations of previously disclosed material. And I refer to your footnote 8 and 9, filing 491, and your latest disclosures, 48 and 49, which were not yet in your submissions. And then we also seek the views of the Specialist Prosecutor's Office on the defense submissions for Mr. Januzi, which is filing 495, paragraph 5 and paragraph 18, regarding a request to disclose certain items and the apparent refusal of the SBO. And if it's not, is it clear enough to what I'm referring, Mr. Prosecutor?
It is, Your Honor.
Okay. Very well. Mr. Prosecutor, do we need to go into private session for your answer, or can we remain in public?
For the first answer, certainly we can remain in public session, and depending on the level of detail for the answer to your second question, we may need to move to private session, but I think I may be able to address that in public session.
Okay. I would say regarding the second issue, so complete as possible, because it's also a request that is laying before us. So, Mr. Prosecutor, you have the floor.
Thank you, Your Honor. In terms of the first question and the new material that's you asked about, the vast majority, if not all of it, has already been disclosed and is being redisclosed under a different rule for notice purposes, essentially. On the second question, I think it's important that we are all operating from the same set of facts, and this has been put into our submissions, and it's also been put in inter partes communications. And if there's any lack of clarity, I'd like to clear it up now. The two devices, which are phones, for which counsel for Mr. Januzi is requesting the SPO to provide access, are not in the SPO's possession. They're in the possession of an... At this point, Your Honor, based on the level of detail I'm going to provide, I think it might be best to move into private session.
Very well. Court officer, could you please bring us into private session?
Your Honours, we're in public session.
Thank you very much, Madam Court Officer. Very well. So at this stage, we have received a proposal from the Specialist Prosecutor's Office to reach out to the defense teams to discuss the pending issue and to see if an agreement can be reached on what questions are pending and on an order to the court to be made regarding the investigations made and the questions posed to us. I leave it for now here. There's nothing on the table of the panel yet, but we applaud that there is this inter partes outreaching, and I hope that this spirit of cooperation will continue, because that is the way we can go forward in a fair and expeditious way in this trial, and that's the ultimate scope. Very well. Next point on the agenda. The panel requested the Specialist Prosecutor's Office to indicate whether it intends to disclose to the defense further exculpatory evidence under Rule 103 or further material or evidence under Rule 102, Paragraph 3 of the rules. And if so, how many items and when? And we asked the SPO if it intended to request protective measures for this material or evidence, and if so, when. Very well. This point on the agenda. We have noted your submissions, Mr. Prosecutor, with regard to Disclosure Package 42 and Package 44, and that newly discovered potentially exculpatory items will be disclosed to the defense without delay on a rolling basis. Very well. We also noted your submissions regarding Rule 102, Paragraph 3 and Rule 109 under C of the rules. And we would like to hear from the SPO if there are any additional observations on this topic.
Thank you, Your Honor. There are no additional observations or submissions at this point.
Good. Then we leave it here for the moment. Yes. Then we come to the point under C. The panel requested submissions from the defense teams on whether they have completed their investigations. And if this is not the case, whether they anticipate carrying out further investigations, and approximately how much time they will need to finalize such investigative activities. And before we give the floor to the defense, I want to recall what I said at the beginning of today's hearing. The scope of this case is limited. We have procedure going on for a year as regards Mr. Januzi and Mr. Bahtijari, and 10 months as regards Mr. H.Shala. They have been detained. Therefore, at this stage of the proceedings, we expect to receive concrete estimates as to the completion of the defense investigations in order to ensure that the trial is conducted expeditiously. If there is a need when you give your submissions to go into private session, please inform the panel. Regarding the submissions, in short, we noted for the H.Shala defense that investigations are ongoing and that the defense is not in a position to specify how much time it will need to finalize such investigative activities. And then for the Bahtijari defense, we noted, also in short, that investigations are ongoing. My apologies. For the Bahtijari defense, we noted that you have nearly completed the investigations. 1 month will still be required. And we have received a list of witnesses last Friday, filing 502. And for the Januzi defense, we noted that it anticipates carrying out further investigations, and I noted both field investigations to be completed by the 11th of November and some digital examinations. Yes. And I will not go into further details, but those were the 2 points I noted. Defense counsel for Mr. H.Shala, could you indicate, based on the information you have now, how much time you would still need for the investigations?
Certainly, Your Honour. At the time of filing the written submissions, obviously we wanted to identify what matters were to be discussed today, which would give us an indication as to what further investigations were required. Certainly our position is that any investigations will be completed by the target date of 11th of November for the start of the trial. Of course, the extent to which the prosecution presents their case may have an impact on further investigations that we need to undertake. But certainly we will be in a position in advance of the 11th of November to give an indication as to what defence witnesses we intend to call. I can certainly say at this stage that it is anticipated that Mr. H.Shala will give evidence in presentation of a defence case, and that there will be no more than 3 or 4 witnesses, which would be very short witnesses, to be called, one of whom is expected to be an expert witness. We will be able to, on a rolling basis between now and the 11th of November, confirm that position as to the extent to the defence case that would be presented. But of course, a lot of that does depend upon matters that are ongoing, the inter-party communications that we will now have with the prosecution, but we certainly don't expect it to extend past the 11th of November.
Thank you, Defense Counsel. That was helpful. Defense Counsel for Mr. Bahtijari, is there something you would like to add in addition to my summary?
No, thank you. We're aiming to be complete by the 2nd of November. We're going to try and take a lot of statements in writing because that will be even more efficient. And as you know from our written submissions, there are still some names that we haven't provided to the court, so we hope to do that by the 2nd of November so that you can have a final conclusive list. We're hoping there won't be any slippage. We'll definitely have completed our investigations by the 11th of November, that we're confident we can do that. I hope I'm not overconfident. I say all of that excluding issues around medical evidence, which I don't propose to mention now, unless you wish me to. That relates to everything else.
Thank you, Defense Counsel for Mr. Bahtijari. You mentioned the date of the 2nd of November. That is a Saturday, and that...
sorry.
No, and for my understanding, that is a date, because I went through all the filings to see this date of the 2nd of November. It's a deadline you have put to the defense team for Mr. Bahtijari, if I understand
well. We gave
it
to ourselves, yes. I hadn't quite realised it was a Saturday, but we've given it to ourselves, and that's why I qualified it with there might be a little slippage, but we're aiming to be ready by the 11th of November.
Thank you. That is clear now also to us.
I'm sorry you had to go through other material. I do apologise.
You don't have to apologise. Part of our work, of course.
Thank
It was
you.
just the 2nd of November, just to point that out. Thank you very much.
Sorry, thank you.
Very well. Specialist Counsel for Mr. Januzi. I noted that your investigations further encompass some expert examinations on evidence. We discussed it before, and there will be an inter partes discussion partly on this. How long because you are also foreseeing other expert investigations. How long do you expect that these investigative steps will take?
Before I answer that, Your Honour, can I revert back to the SPO's position and the questions asked about their remaining matters before they are trial ready?
Let me say, a moment, please, just to read again what you have said. Before I answer that, Your Honour, can I revert back to the SPO's position and the questions asked about their remaining matters before they are trial ready? Now, yeah, I want to know how long, we want to know when you will be, your team will be trial ready, and what investigative. No, wait. Let's not talk over each other. I will give you the floor. How much time you foresee you will still need?
I understand that, Your Honour.
Please, I will give you the floor. So if you think that going back to the position of the Specialist Prosecutor's Office will assist your answer to the panel when you think you will be trial ready, then of course we can go to that point. And if not, I would rather not discuss it now.
No, thank you. Your Honour, obviously I've asked to go back to that point because it assists with the answer to the question that Your Honour asked me. The submissions in writing that the SPO submitted ahead of this trial preparation conference said at paragraph 3 that they envisaged the service of further evidence. 3 items in particular are referred to. The second item, under Roman numeral 2, appears to be relatively short. I'm not overly concerned about that. But the other 2 matters are potentially matters that may require further investigations on our behalf and relates to the issue of potential expert evidence. The first item talks about reports that the SPO has received from the external forensic institution looking at telephones seized from the 3 accused. The third item referred to cell site data and the use of maps. Now, those matters are potentially, we can understand why the SPO are looking to serve such material, but I need to know when we're going to have that before I can answer the question that Your Honour posed to me in relation to our expert investigations, how long we are going to take before we can deal with that material. So I would ask the court to invite the SPO to say when we will receive that evidence that they envisage serving upon us.
Thank you, Defense Counsel. For next time, please don't interrupt me when I'm talking. It doesn't help our exchange. Having said that, I will invite the SPO to give an answer to your question, but apart from that, if we leave aside the question you have posed to the Specialist Prosecutor's Office, how much time do you think you will need to conclude your investigative actions?
Well, the second body that has made it difficult for us to provide a straight answer to that question is, I'm afraid, the registry. At the outset of this hearing, Your Honour, you invited all parties, not only the SPO and the defence, but also the registry, to work cooperatively and collaboratively to ensure that the trial can be brought on as quickly as possible. I join, Your Honour, in exhorting all my colleagues at both the prosecution and defence, but also the registry to join in that exhortation. I have to say that in my years of experience, I have never had a case in which trial preparation has been so difficult and dealings with funding being so obstructive
Defense counsel,
as in this case, Your
defense
Honour.
counsel, we will not go into this part. I want to know from you if you can inform the panel on the finalization of your investigative steps. We are aware of the discussions that have been going on. I don't want them to be repeated now in court, because I want to use our court time to focus on what we have to do. And we have to prepare this case for trial. And I see, and I've listened, and I've read the consultations and the exchanges that have been going on. But for now, for me, it's really important, Mr. Rees, is to understand where you stand and what you see in time, in terms of time issue. That's what I want to discuss. If there's something on the table that this panel should decide on, we will do that. But it will not help us any further if we are going to repeat, and I say that with all due respect, that part of the discussions. What do you need to finalize? That's what I want to know. What do you need to finalize your investigations? Because
we need the registry to agree, Your Honour, that we can travel and carry out our investigations.
No, we are not going. We are going to private now. Madam Court Officer, could you bring us into private session, please?
Your Honors, we're in public session.
Thank you, Court Officer. So, Defense Counsel for Mr. H.Shala, I see you would like to have the floor, but I will first make a remark and then I will give you the floor. Yes, Defense Counsel for Mr. Januzi, we have been now in private session, but I note for now that you're not in a position awaiting the further information that you will be provided with by the SPO to give an estimation of when the investigations will be finalized. I can say that you will be doing investigation steps in the field, investigations in the field that will take you about 5 days. That's
right.
Thank you. And we have discussed that the registry has made the point in private session that there are funds available for all defense teams amounting to amount of money to do expert investigations. So that can be used for any type of investigation you need to do.
Understand that.
Okay,
It's also
Defense Counsel, I'm just making a summary. It's not that I'm inviting you to talk. I think it's very important that part of our discussion that has been done in private is also shared with the public. And I realize that part of our discussion could be done in public, but because of some topics had to be done in private. Just want to share that with people who are following these proceedings. Yes, Mr. Rees, I propose that you can submit your request to the register with regard to the funding at the earliest possibility, because that can be done today. So we don't have to wait for any evidence to be disclosed to the defense parties.
But, Your Honour, it's our position that obviously the registry requires us to submit a plan of activities, including what we intend to do in relation to any independent external investigators. We have to obtain prior approval effectively, and there's nothing wrong with that. That is understandable, and I don't take any objection to that. But that requires us to obtain an expert to provide us with a quote for the cost of the work. The quote depends on the extent of the work that we're asking him to do. The SPO are telling us that within 7 days we will be receiving further material relating to our phones. I've heard very well what Mr. Havitz has to say. In his view, I'm not going to repeat it, Your Honour, as to the nature of that material, but you will understand that we, as part of the defence, would like to see the material ourselves to consider the nature of it and to what extent it requires further work. That will be provided to us in 7 days. As I have said to Your Honour in closed session, we will immediately look at that material. We will immediately assess what work is required. We will immediately then obtain a quote from an expert that we want to look at the hard drives together with this material. And then we will immediately ask the registry to give its immediate approval. And we will do that in order to act as expeditiously as possible, as we have been throughout proceedings. We could have, at an earlier stage, Your Honour, asked for approval previously, but we were told, contrary to the guidance on the administration of legal aid, that no services could be provided before a contract enters into force. But we are where we are. We will undertake to take those steps immediately
Okay,
as
now
soon
we
as the
don't,
SPO
we don't have to,
discloses that
no,
material.
no, I don't give you the floor anymore. We're not going to repeat ourselves. Once is enough. I've heard what you're saying and I heard that you want to do it expeditiously, but please, don't take up the time in this way.
No, I'm grateful,
No,
Your
no,
Honour, I won't.
no. Very well. We're going to the next point, and that is point D. And, oh, you're right, yes, thank you. Defense Counsel for Mr. H.Shala, you have the floor. Apologies that I forgot about
Thank you, Your Honour. I don't want to extend the conversation any more than is absolutely necessary, but just as a very, very short point, Mr. Rees is correct on the point that what we have so far is inaccessible. And through no fault, and I'm not pointing the blame at the SPO, the format in which it's been given to us, we have been unable to access the hard drives because there's so much data that it just crashes the system every time. Now, that may well be the executable file that we have through Cellbrite is not a full license, so we cannot open it. Now, there may well be a very simple explanation to that and a very simple solution. It may well be providing the defence teams with a full licence so that we can actually access the material, even if it's here in these facilities, so that we can actually see what's on those drives and we can identify whether we even need to instruct an expert. So my request would be, if a full licence is required, each defence team should be provided with a full licence so they can access that material. If that is not the case, then there has to be a solution provided by the SBO that enables us to be able to access the material so we can make that determination.
Okay. Thank you very much, Defence Counsel. Allow me this question. When did the defence parties receive this material?
So we've received it on a number of
Yes.
different occasions. A further drive is being provided to us today. We have had our own experts trying to access the material. It's just been unsuccessful in the way that it's been provided to us.
I will ask, thank you, Defence Counsel. Mr. Prosecutor, when was this provided to the defence?
Your Honor, I apologize. I don't have the exact dates
Less or
of
more.
each disclosure, but for several of the phones, it's frankly quite some time ago. So I'm confused as to why this issue is being raised now, but I can get you the exact dates
Okay. No,
after our next break.
it's just what I would like to invite parties that in this courtroom, I prefer not to go into technicalities. What I would like is that there is an inter-partes exchange on to open these files. And what for me is still not very clear is why this topic is discussed now, because this is something that should be done in the spirit of a cooperation. If you realize you cannot open it, you go to the SPO and you discuss it with the O in order to have it opened. So I leave it for now here, and I urge parties to get it organized. I mean, I think we close the discussion here.
Absolutely, Your Honour. And this is material that has been disclosed some time ago, but these are issues that we have raised with the SBO previously. So it's not a matter that we haven't attempted to resolve it, but certainly in the spirit which is coming out today, perhaps we can have a further discussion with the SBO and resolve this.
I see a raised hand from the defense for Mr. Bahtijari. You have the floor.
Thank you. Just very quickly, I did manage to download Cellbrite. I notified the SPO. I have been able to access the phones, but the advice from IT in the building is that the computers within the building are not strong enough to hold the Cellbrite. Mine just about holds it if I don't use it for too long, and it may well be that the computers that have been supplied to counsel for the other defendants are just not strong enough. So I asked for a new computer that would be strong enough. I didn't get one, So we're muddling along. So if the solution is to have a better computer in the office, we'd like that solution.
Okay.
But the software is on the hard drives that we've been provided with. You download it, it takes about, well, you have to leave it for about 12 hours overnight, and then you can sort of access, but it's better to have a computer. Nothing else to say, I just thought that might be helpful.
No, thank you, Defense Counsel for Mr. Bahtijari. I also would say this kind of technicalities, I think they're very helpful, but I prefer not to have them discussed during court time. That's really, I think it's a pity of the time, but it is helpful. So I would, all this technical information, share it with your colleagues and with the relevant people at the premises to further, to make it work. Very well. No hands. I do a double check. Good. Next topic. The panel asked the defense teams on whether and when they can already anticipate disclosing evidence and amending their respective pretrial briefs and or their list of potential witnesses. Very well. Defense Counsel for Mr. H.Shala, I noted from your submissions that you would give the panel an update on the need to disclose evidence, the need to amend the defense pretrial brief, and or the list of potential witnesses. Before I give you the floor, would you like to go into private session for your submissions, or do you prefer to stay in public?
We can stay in public session.
You have the floor.
Certainly the point that was put in the written submissions was an abundance of caution, and depending what happened between then and now. Certainly I've indicated what the defence witnesses' requirements would be. I think we've set out our position as far as disclosure is concerned. I don't think we need to add to that today. And certainly at this stage we haven't taken a decision as to whether any amended pre-trial brief would need to be filed. But it was the point was made at the time, depending what had happened between then and now, as to whether any amendment to the pre-trial brief would be required. But certainly, I don't think we anticipate filing any amended pre-trial brief at this stage.
Now, the defense is not in a position to say whether and when, as a resulting of these investigative activities. Yes, it's yours. It can anticipate disclosing evidence and amending its pretrial brief and or its list of potential witnesses. An update will be provided at the trial preparation conference. So that's the reason that I ask you if you have any information to share with us.
Other than what I've said already, nothing further. What we can certainly indicate, as I have already said, it may well be just an addendum to the pretrial brief is necessary, which is just setting out certainly any defence disclosure which will be required, and setting out the defence witnesses, as I've indicated, prior to the 11th of November. Obviously, we'll do that as quickly as we possibly can. We're not in a position today to set out those witnesses and what their evidence will go to, but certainly that will be done as soon as practicable, and certainly before the 11th of November.
Okay. I must confess that I had hoped for a little bit more elaborate update today, but I note it for now. Yes, thank you very much. Specialist Counsel for Mr. Bahtijari, the panel has taken note of your submissions. We have the following questions for you. Do you intend to disclose evidence? Do you foresee the need to amend your further updated pretrial brief? And I note again that we have received your witness list, which is not final as I see it, but there is a list last week. And then in addition to this, two questions regarding the evidence to disclose and amendment of your pretrial brief. If you could clarify your submissions regarding the assessment for the need for closed session submissions in paragraph 494, paragraph 11.
don't have that in front of me at the moment, so
No,
just
I
bear
can-
with me a second.
Of course.
I'm sorry.
No, don't worry. You.
The remote desktop sometimes drops out quickly.
I don't want to read it out, so we can go into a private session for this, for the answer to this question, and then I can read it out for you. But the other two questions, I give the floor to you.
On disclosure, we have communicated with the prosecution about proposed agreed facts in relation to recordings on phones. That's going to be capable of agreement. On the contents of our client's phone, we're just double checking some of that content, and we did set out that we think that some additional content can probably be capable of agreement. For example, our client around the time of April 2023 is Googling the weather and not the court. So there will be a little bit of additional evidence that comes from the prosecution material. Otherwise, any disclosure from us will be through witnesses, and we will endeavour to give as much of that information in advance. We don't anticipate updating our further updated pre-trial brief. We did 3. We did that to try and get disclosure. There are still a couple of things outstanding that we probably want to deal with in private session. And closed session, in my mind, without reminding myself of that paragraph, relates largely to Mr. Bahtijari's health.
Okay. Thank you very much. We will go into private session just to further clarify this point.
Thank you. I'm sorry I don't have it in front of me at the moment. I'll try and fix that.
Court officer, could you please bring us into private session?
Your Honors, we're in public session.
Thank you. Now we go to the Specialist Counsel for Mr. Januzi. I noted from your submissions that you don't know when you will be in a position to disclose further evidence and amend your pretrial brief and your list of potential witnesses. Do you want to make any submissions on the item of the agenda topic in addition to what we have been discussing up till now?
Yes, let me try and assist in this way, Your Honour. We have said, and we maintain this, that as providing that everything goes smoothly from here on, we hope to have carried out our field investigations by the 11th of November. We will, if that happens, I can undertake that we will provide any updated pre-trial brief and list of witnesses by the 18th of November. I hope that assists.
Thank you, Specialist Counsel. Okay. Before we proceed to the next point on this matter, the panel stresses that it foresees that if the SPO, and we will discuss that later on after the break, would be able to finalize its case in November 2024. And we will get into more detail on the possibilities regarding the start and ending of the SPO case when we discuss the next item regarding the conduct of proceedings, the commencement of the trial and the planning in this regard. But that is for after the break. So if the SPO would be able to finalize its case in November 2024, the defense cases could start in December 2024, subject, of course, and I note the submissions also of the defense teams, subject to any decision on Rule 130 of the rules. Yeah. So therefore, the defense teams are expected to prepare with this timeline in mind. And the defense teams are invited to liaise who will present its defense case. And this is all if, and if. Huh? Who is to present its case first? In principle, we could leave that for the defense teams, and if not, the panel would take a decision on that. But we come to this further on. I just wanted to give this before, as an intention of this panel. Then we have one last point regarding the ex parte closed sessions. We received the submissions of the parties and we noted them, and I don't think it's necessary to go into them at this moment. So then we are a little bit before 11 o'clock, and I think it's a good moment to adjourn the hearing for 30 minutes. We will see each other back at 11:30. The hearing is adjourned.
All rise. All rise.
welcome again after the break. I will call appearances, and if there have been no changes, it suffices that you indicated that is the case. Yes, Mr. Prosecutor, I start with you.
Thank you, Your Honor. All present from earlier this morning, other than the specialist prosecutor, has returned to other duties. Thank you.
Thank you. Deputy Registrar, you have the floor.
Thank you, Your Honor. No changes from the registry.
Very well. Then I go to the defense teams, and I start with with the defense counsel for Mr. H.Shala.
No changes, Your Honor.
Very well. Then I go to the defense counsel of Mr. Bahtijari.
No changes, thank you, Your Honour.
Thank you. And then the defense counsel for Mr. Januzi. You have the floor.
No changes, thank you, Your Honour.
Thank you. Very well. Then we continue with the next point on our agenda, which is the conduct of proceedings. It includes several items, and I will go through them in sequence. The first point is the commencement of trial and opening statements. The panel has received submissions from the parties as to the date for the commencement of the trial. We have taken note of these submissions. The SPO is prepared to begin trial on Monday, 11 November 2024. We noted the defense for Mr. H.Shala and for Mr. Bahtijari do not oppose to the date of 11 November 2024 for the commencement of the trial. And we received submissions for the defense for Mr. Januzi. It was indicated on Tuesday, 1st October, that there were no submissions to make as to the date of the 11th of November for the commencement of the trial. We have received an email on Thursday, the 3rd of October, that the Januzi defense may raise whether an alternative date could be accommodated for the prosecution opening due to a new judicial commitment of specialist counsel raised on the 11th and the 12th November 2024. And we received an email on Friday, the 4th at 12:47 that the defense for Mr. Januzi would request at the trial preparation conference to move the prosecution opening statement to the 13th of November because a previous commitment on the 13th of November had been lifted from his diary. Now, thank you very much for these submissions. Noting that the SPO is prepared to begin trial in November 2024, and in order to take full advantage of all preparations, the panel intends to anticipate the commencement of the trial to Friday, the 8th of November, and asks parties to ensure their availability for that day to give their opening statements. And this includes having co-counsel for the defense to appear instead of the counsel if lead counsel is unavailable. And the panel further intends to use the full week of the 11th till the 15th of November for trial hearings and ask parties to ensure their availability for that week. We will come back on this later in private session or in public session, depending what we can discuss in public. But this is with regard to the commencement of the trial and the opening statements, and even hearing the witnesses, what the intention of the panel is at this moment in time. Yes, we will go further to some other issues, and then we can further discuss this intention of the panel. Very well. The panel instructed the defense teams to indicate whether the accused object to the SPO reading a summary of the indictment at the opening of the case, instead of the indictment in its entirety. And the panel notes that the H.Shala and the Bahtijari defense don't oppose to the SPO reading a summary of the indictment at the opening of the case. However, the defense team for Mr. Januzi would like to receive a copy of the proposed summary in advance with the possibility to object thereafter. Mr. Prosecutor, you have the floor if you would like to respond to the defense for Mr. Januzi on this point, on this proposal.
Your Honor, only short further submissions. We've noted the position of the Januzi defense, and we will consider it and remain in contact.
Could you be a little bit more concrete?
Just, Your Honor, that we understand that as a request, and we will evaluate it. We don't see a large problem potentially with providing them a copy of the summary, which they can object to later in court in any case.
Yes. A possibility could be, although I think it's a prerogative in principle of the Specialist Prosecutor's Office to formulate the charges, but we could proceed with reading the charges as formulated and read out in the pretrial phase during the initial and further appearance. And that text, if I understood well, is taken verbatim from the amended indictment. And of course, we can also read the whole indictment if the defense so wishes. I note the observations of the SPO.
Thank you, Your Honor, and we note your suggestion regarding the previous reading of the document. Thank you.
Good. Defense counsel for Mr. Januzi, is there something you would like to add in this respect?
We hope that the suggestion was a sensible one, that we would, if we see a summary in advance, not have an issue as long as the terms of it can be agreed. In the absence of the prosecution agreeing that course of action, then we'll request that the indictment be read in full. So it's a matter for the prosecution. If they wish to read the summary, they can provide a copy to us and we'll deal with it on an inter partes basis, Your Honour.
Thank you, Specialist Counsel. And the text as read out during the initial and further appearances, would that suffice?
I'd have to review it. If that's the prosecution's proposal, then we'll review that and we'll indicate in writing whether that suffices or not.
We note your observations. Thank you for that. We will issue an order on this matter, or we will give further directions in our decision on the conduct of proceedings. Very well. Then I take points C and D together. We requested the SPO and the defense teams to indicate whether they intend to make an opening statement pursuant to Rule 126, paragraph 1 of the rules and related matters. We have taken note of the submissions of the parties, and I leave it for here without summarizing them. We also requested the defense to indicate whether the accused intend to make unsworn statements pursuant to Rule 142, paragraph 1 of the rules, and if so, whether this will take place together with the defense opening statements or at a later stage. We have taken note of the defense submissions as to whether the accused intend to make an unsworn statement, and in the affirmative when. So that's noted. Thank you for that. Then the second topic, that is familiarization of witnesses prior to testimony. We have received your submissions on this issue, and we have taken note of the submissions of the SPO regarding the advantages of witness preparation. The panel notes the H.Shala defense has no objection to the guidelines on witness familiarization adopted by the panel in case 04. We also noted that the defense for Mr. Bahtijari indicated that it is content to follow the usual practice, and we also noted, yeah, that's what we noted. And the panel would like to underline, in respect to your submissions, defense counsel for Mr. Bahtijari, in paragraph 20 in submissions 494, that all witnesses called to testify live in court go through the familiarization process if the panel decides to continue with its prior approach. Very well. And we note that the defense for Mr. Januzi did not express itself on this matter. Defense counsel for Mr. Januzi, is there something you would like to add in this respect? I see you saying no.
not.
Thank you. Okay, and then the registry makes no further submissions on the approach taken by the panel in case 4 and 5. And we noted the annex to the submissions, the guidelines and instructions of WIPSO has developed on the support it provides to witnesses prior, during, and after the testimony. Okay, thank you for that. Having said that, I proceed to the next topic, unless there is a point with regard to familiarization one of the defense teams or the SPO wants to make.
I presume we're just dealing with familiarization at this
Yes.
stage, not preparation.
No.
In that regard, I have nothing further to add.
No. In case there was any unclarity, defense counsel for Mr. H.Shala, the prosecution has pointed out some of the advantages they see in preparing the witnesses, and I noted that we have seen that. Very well. Let me see. Yes, third topic. That is the presentation of witness evidence and non-oral evidence by the parties. Under A, we instructed the SPO to confirm that its list of witnesses and the requested time for direct examination of those witnesses and its list of exhibits are final. And we have taken note of your submissions, and in particular we note that the SPO has reduced the estimated duration of the examination of witnesses it intends to call. We have seen the public redacted version of your submissions, and we also saw that you have made public the number of witnesses the Specialist Prosecutor's Office intends to call. So I was going to ask you if we had to go into private, but this can be disclosed. So very well. So we have 2 witnesses on the list. With regard to the estimated duration of the examination proposed by the SPO, I refer the defense for Mr. Bahtijari to the annex of the submissions of the filings of the Specialist Prosecutor's Office, where they gave an indication of how long the intended examination in chief will take. Yeah? Mr. Prosecutor, would you like to make any further submissions on this matter?
Very briefly, Your Honor, thank you. Our list is, as we said, the list of 2 witnesses is final, with one caveat that I think can be inferred from the filing, but just to make it more explicit, because I know the court is very focused on efficiency and timing and planning, and for the defense as well. There are several pieces of evidence, some of which have been discussed already today, that are on the exhibit list, which the defense has already indicated they're going to challenge on a variety of grounds, and that we expect them to flesh out and file on to the extent they haven't already, and some of them are fairly detailed already. We noted in our filing that we intend, and I can say now it will be within 2 weeks, we intend to file with the panel requests for the admission of certain of this evidence, which is documentary evidence. Most of it is, just to be clear about what we're talking about, most of it is evidence extracted from mobile phones.
Okay. But this is admissibility of evidence. We will be dealing with it later.
But the only reason I'm
Oh.
raising it now, Your Honor, is
Okay.
it informs the finality of the question. I just want to caveat that should the SPO need an additional witness or witnesses to explain or respond to challenges in the court's view to gain admissibility of that evidence, or for the court to make the most informed decision, it is possible that we would seek to amend the witness list with those one or two witnesses that would be necessary for that purpose. That's why I flag it now. It is our view, which is why we're doing it, that the motion that we make within 2 weeks will be sufficient without calling a live witness to admit that evidence. But I just wanted to flag for the court that potential eventuality. And otherwise, the list is we view as final.
Thank you, Mr. Prosecutor. Yes. The defense teams were instructed to confirm if their intention to present a case. Now, we noted that each defense team intends to present a case. And we also asked the defense to provide information as to the status of their respective list of witnesses and the requested time for direct examination of their envisaged witnesses, and as well whether they intend to request admission of prior statements or transcripts in lieu of oral testimony under Rule 153 to 155 of the rules. And very well, we have already received some information in this respect from the defense teams. I will come to that later. I will now first note a request of the Januzi, of the defense for Mr. Januzi, to request a witness summons. And defense counsel for Mr. Januzi, you intend to, do I understand well that you intend to present a request for witnesses to be summoned?
I do.
Yes, thank you. On this matter, Specialist Counsel, you would first need to present a final witness list as well as a summary of their intended testimony, and that goes for, of course, all defense teams. And after our assessment of the list of witnesses, the questions of the summons will be addressed, if still relevant. So a request of this kind, at this stage of the procedure, is premature.
Can I?
Of course, please. You have the floor.
Okay, I do understand what Your Honour has said. Obviously, the three witnesses that I've indicated we intend to seek a witness summons in relation to are, two of them are officers of the SPO. One is an officer of an independent external forensic investigation unit. I can put aside for the moment the external investigator, because whether or not we need a witness summons in relation to that official may depend on the inter-parties discussions that Mr. Havetz raised relating to the two mobile phones at the very outset of the day. I'm hopeful, therefore, that those will bear fruit, and we don't need to worry about that third official who is external to the SPO. The other two are SPO officers. And the reason why we've raised at this early stage the prospect of a witness summons is because we have asked on an inter-parties basis for the prosecution to make those two officers available to give evidence. They can either call them and engage in direct examination with them before we then cross-examine, or they can tender them for cross-examination straight away. and they've indicated that they're not willing to do that without an order. The other course of action would be for them to make the two officers available for us to conduct interviews with. If they do that, we can then prepare a summary of what we anticipate that they would say, as Your Honour has requested. But unless they make those two officers available to us, then we're not going to be able to go through the process of submitting an application together with a summary of the evidence that they can give. We will only be able to draw, to rely in, for the purpose of the application, on the circumstances which we know we can establish that they can speak to. Exactly what they'll say, we would have to wait until their evidence. I would, the prosecution are well aware of the issues that we seek to speak to these two witnesses about. And it would be another course of action that could resolve this if the SPO takes statements from those two officers as to the circumstances that are referred to in the pre-trial brief. And then we can see what those statements say and take it from there. But at the moment, the SPO are not engaging with us, so that we've had to raise at this early stage with the court. Well, it looks like we're going to be left with no option other than simply ask the court to order the two witnesses into the witness box, and we will explore their evidence as they give evidence itself.
Thank you, Defense Counsel. Is there something the Specialist Prosecutor's Office wants to submit?
Your Honor, the only thing I would add is I think the course the panel has set forth is the proper course, and we'd only ask if such written submissions are ultimately made that we be entitled to respond in writing before a decision is made.
Thank you. Very well. Yes. Now, yes, you have the floor, Defense Counsel, for Mr. Januzi.
Thank you, Your Honor. But Mr. Havitz's response does not help take the matter further one way or the other. I've raised two potential courses of action for the SPO to consider, which will help further the preparation of this trial so that we can expeditiously progress from opening statements to evidence to closing the prosecution case and then moving on to the defense case.
Thank you for setting out the order of things. Defense Counsel for Mr. Januzi, I've noted your submissions. Yeah, I've heard very well what you've said, also what Specialist Prosecutor has said, and we will consider it. And I have also indicated for now what the panel would see as an appropriate course of action. But we take your submissions on board, and if there's a need, we will come back on this. Very well. Next point, or not the next point, you were asked, and I'm talking to the defense teams, to get back to us as regard of the status of your list of witnesses. And we have noted them, we have been receiving them during today's hearing. And I would like to invite the defense teams to give, to share your views on submitting by Monday, the 4th of November, a list of witnesses with the relevant information. And with the relevant information, I mean list of witnesses, a summary of what they will be testifying on, the time you think you consider that will be needed for examination, or whether you want to file it through Rule 153 and 153 till 155, and the modalities. I mean, a complete list of witnesses like has been submitted today, has been submitted by the Special Prosecutor's Office to its submissions of the Trial Preparation Conference in the Annex. So Monday, 4th of November, or an alternative date, bearing in mind that with all the, I know, in Dutch we would say mits en maar, but with all questions pending, we consider the defense cases to begin as soon as December 2024. I will first give the floor to to the defense counsel for Mr. H.Shala, please.
Your Honour, I think the 4th of November is entirely reasonable, and certainly we will work to that. Obviously, as the SPO has indicated, they're going to be making a filing in 7 days as to what they're going to be adding to the exhibit list. We have been in communications previously as to who they're calling as witnesses. Obviously, it's a matter for the prosecution as to how they present their case. As we know, they're only calling 2 witnesses. That may be adjusted depending upon their filing, and obviously how we respond will depend upon their written submissions. But certainly, I see no reason why the 4th of November that the H.Shala defence cannot provide the court with what you have directed.
Thank you, defense counsel for Mr. H.Shala. Then defense counsel for Mr. Bahtijari, you have the floor if you would like to make further submissions.
No further submissions. 4th of November is fine. Thank you.
Very well. And defense counsel for Mr. Januzi, you have the floor.
We can't comply with the 4th of November, Your Honour. I suggested before the break the 18th of November, and I would maintain that date as the earliest possible target for us, assuming everything goes smoothly. We are, as I mentioned earlier, I won't go into the details because Your Honour has asked me not to, but in negotiations with the registry about arranging our investigations in the field, the timetable for those investigations would not have begun by the 4th of November necessarily because of the policy of the Defence Office. So we won't be in a position to do it by the 4th of November. We will be in a position to deal with it by the 18th of November.
We have noted your submission. We have noted your submissions. I heard a mic.
Sorry, I've just had one final thing. I don't envisage that being a problem with the ultimate target that Your Honour said, which is the defence cases beginning and even concluding in December of this year.
Okay, yes. Very well. Mr. Prosecutor, you have the floor.
Thank you, Your Honor, and I apologize for the interruption. Just to make sure there's no lack of clarity, and I apologize if it was my lack of clarity, to counsel for Mr. H.Shala's point, our submissions on the for the motions of evidence would be within 14 days, not 1 week. We anticipate making those within 14 days.
The 7 days was with regard to the evidence you would like to add to the exhibit lists on the datas from the telephones.
Yes, thank you for that, Your Honor. And if I may, just one point of clarity on that, which actually may expedite that further. During the break, it occurs to me, since we have everything but item little 3 of those items, it may be most efficient for us, especially since there's seems to be a delay in accessing the information without that those reports. We could file our request to amend the 1021B list for those 2 items. That for the things we do have, we could file that by tomorrow morning and then disclose them, and then file a separate one for the missing item. That may expedite things and move it along a bit.
Everything, Mr. Prosecutor and defense teams, that can expedite in a fair way. We are not going to rush. Let me insist on that. But if we can expedite, we really should work to it. Thank you.
So we will do that.
Good. Yes, I see Mr. Edmund nodding, and also the other defense teams, there cannot be other than approval, of course. The sooner the better. And I see Mr. Rees nodding, and if I could receive a nod of the defense counsel for Mr. Bahtijari, yes, very well. Next point. The defense teams have been asked whether they intend to offer a defense of alibi. We have taken note of your submissions. Can the defense for Mr. Januzi confirm it will not present an alibi defense?
No, we won't be providing an alibi defense.
Thank you. None. The next topic is the order of appearances and issues related to the questioning of witnesses. The SPO was instructed to file written submissions as regards the order in which it intends to call the witnesses, included in the SPO list of witnesses, the modalities of the witness testimonies, live or video link, and the possibility for a first witness, we said then, to be heard during the week of the 11th till 15 November 2024, following any opening statements by the parties. We have taken note of the SPO's readiness to begin with a witness testimony following completion of the opening statements. Considering the number of witnesses, 2, which is now public, and the estimated time for examination of witnesses requested by the SPO, we would like to receive the SPO views as to the possibility to hear said witnesses, so both, and then both examination and cross-examination, and whatever comes after, in the week of the 11th till the 15th of November, while starting on Friday, the 8th of November with the opening statements. So if it's possible from the logistic point and other point of view. Content related.
Yes, Your Honor. At this time, that works for us.
Okay, very well. And the registry, I would like to invite you to make submissions, if any, from an operational point of view, if this would be feasible.
Thank you, Your Honor. Yes, very shortly, it's feasible for the registry to facilitate the presence of the 2 witnesses during that week.
Okay, thank you for that. The panel would require the availability of the defense teams for the Friday 8th of November and the whole week of November in order to try to finalize the SPO case in that week. And that would include the 14th and the 15th of November. This would allow the Specialist Prosecutor's Office to conclude, and I have heard the possibility of a third witness, and we are planning here, because to govern is to look ahead, we say in Dutch. That's the only way we can make things work. This would allow the SPO to conclude the presentation of its evidence in the week from the 11th till the 15th of November. And we therefore ask the parties, the defense teams, to ensure and to confirm their availability for not only the 8th, which is the Friday, but also the entire week from Monday 11 till Friday 15th of November 2024. And we would kindly receive your confirmation by tomorrow 1 o'clock. Very well. Submissions on questions regarding the order of appearance and issues related to the question of witnesses were requested from the 3 defense teams. And the defense teams responded that for now you are not in a position, but we have heard when you will be in a position. So we noted that, and in our directions and oral orders, we might come back to this specific issue. Next topic, and that is the last topic on our agenda for the submissions. I will give you the floor. Please allow me. Yes. This will be the last topic from the agenda we have in the submission, in the decision we sent to you regarding the trial preparation conference. Defense Counsel for Mr. H.Shala, you have the floor.
The only comment I would make on the order of presentation of the prosecution witnesses, and certainly we can indicate what we believe would be the amount of time required for cross-examination as far as Mr. H.Shala is concerned for each of those witnesses. But what I would not want to see is for us trying to make sure we fit everything in that week and then have one of the witnesses, potentially the second witness, dealt with partly in November, partly in December, just for the panel to be conscious that it is desirable for the witness, both examination in chief and cross-examination, to be dealt with within that same time period. So if that means it has to go off to December, I think that would be the preference rather than breaking it off partly in November, partly in December, if that makes sense.
I'm looking again, the only thing for the... what the panel intends to do, maybe that would be the clearest thing, that we would do the cross-examination per witness. We would examine the first witness completely, and then we would proceed, all defense teams, and then we would proceed to the second witness. That is how we intend to proceed. And if that, the idea would be, the planning would be that could fit in that week, and if it for one reason or the other, or we foresee already on beforehand that it would not work out in that way, then of course, I already told you, we are not going to rush. Yeah, clear?
I'm grateful.
Very well. Then we go to the last item on the agenda, which is the non-oral evidence. The panel requested submissions by the parties as to whether the admissibility of non-oral evidence should be decided at the time of its submission at trial, or whether it can be deferred to the judgment after giving parties an opportunity to make submissions, if they wish to do so, on the admissibility of any such items. We have taken note of the submissions of the Specialist Prosecutor's Office. We have some further questions, and you have already given us a heads up on this, but because of the detail of the questions, I would like to go into private session, and then we can see if the matter is prone to be discussed in private, or that we can revert back to public. Court officer, can you bring us into private session, please?
Your Honors, we're in public session.
Thank you, Madam Court Officer. I repeat for the sake of publicity that Defense Counsel for Mr. H.Shala was asked to give further submissions, if any, with regard to his submissions in filing 482, paragraph 19, and he indicated that the point is clear, and in addition, there's no need to make any further submissions than set out in his submissions for the trial preparation conference. My next question will be for Defense Counsel for Mr. Bahtijari. We note that you also will seek exclusion of certain items, and that you consider that such challenges should be decided before the testimony of the witnesses. Defense Counsel, do you want to make any further submissions in this respect?
Yes, we do. And as I understand it, the prosecution are going to make motions in those respects. So we would like to reply to those motions in more detail than we've given you up to now. Please.
You will be given, we will litigate this as foreseen in the rules of procedure and evidence with a moving party with submissions, response and reply. So.
Very grateful, thank you. Nothing else to add.
Noted. And then Defense Counsel for Mr. Januzi, if you would like to make further submissions in addition to your reference to the pretrial brief, and I refer to paragraphs 65B, C and D. Regarding the admissibility and your opposal to them.
Yes. In relation to the matters we've set out at paragraph 65B, C and D, as I understand it from Mr. Havitz, the prosecution are now agreeing to make a motion to admit their exhibited materials, rather like my colleagues, Ms. Gary and Mr. Cadman. I think the best course would be for me to wait to see what those motions say, and I will reply to them in accordance with the rules of procedure and evidence. The prosecution has seen the issues that we have raised in our pre-trial brief. We know that because Mr. Havitz has just acknowledged that shortly before. So we will await their motions. We agree with the prosecution and my learned friends that admissibility in this case should be determined before the relevant witnesses testify.
Thank you, Defense Counsel. Now, this concludes the issues set out in the decision on the trial preparation conferences. I will address some further points in addition to what we have discussed. Yes, the late submission of filings and a related issue. First, the panel notes that the defense for Mr. Januzi files its submissions for today's hearings, filing 495 on the day after the deadline set by the panel and without requesting an extension of time. We also noted that the defense for Mr. Bahtijari filed without requesting leave further submissions for today's hearing on Friday the 4th, which is 3 days after the deadline set by the panel. And we also note that the defense for Mr. Bahtijari did not make a filing on the record with information as to the presence of counsel, co-counsel during the hearings foreseen up until the 20th of December 2024, as ordered in its decision 479, paragraph 32B, and sent an email with that information. We urge the defense to abide by the deadlines and orders or directions set by the panel on any given matter, and to resort to the legal avenues provided under the rules for extension of time limits in case it's not in a position to meet the established deadlines. And we stress in particular that we will exercise our discretion under Rule 9 of the rules to dismiss or not to consider or to dismiss future filings submitted out of time. The party are thus put on notice that by not abiding the directions set by the panel, their submissions and requests may, as a result, not be considered by the panel. Then there is a next point, that is the reclassification orders. And for this part of the session, I would like to ask the court officer to move us into private session.
Your Honors, we're in public session.
Thank you. I saw a hand of Mrs. Of the defense for Mr. Bahtijari, but now the hand has disappeared. I assume that there's no
I
point.
was going to give an explanation, but I don't think it's necessary. I hear Your Honour's orders. You know my personal circumstances last week. I don't think it needs a submission today, and I put my hand back down.
Thank you. At this point, I would like to ask the parties whether they have other issues that they would like to raise. And please be mindful if it can be done in public or in private session. And I will start with the Specialist Prosecutor's Office.
Nothing other, Your Honor, than just to make the court aware that per the Bahtijari request in the submissions for this conference regarding the potential need for a site visit, we have spoken inter partes with counsel, and I'm optimistic that we will be able to resolve the information, obtaining the information that counsel has requested, and it might obviate the need for her request for a site visit. So we'll continue to work forward on that. Otherwise, nothing from us.
Thank you very much. We applaud this inter partes approach to different requests that are outstanding without bringing on board the panel. Is there something are there any further submissions from the registry?
Thank you, Your Honor. Nothing further from the registry.
Thank you. Then I go to Defense Counsel for Mr. H.Shala. You have the floor if you would like to make further submissions.
Thank you, Your Honour. Only one point which hasn't been dealt with, which is the question of witness preparation. Now, obviously, we have made written submissions on that basis. We oppose any form of witness preparation and actually refer to this panel's previous decision in the Salih Mustafa case as the appropriate course of action in this matter. We can, of course, put in further submissions as required, but I just note it wasn't dealt with today.
Thank you, Defense Counsel, for your submissions. I said today, earlier, the panel notes that the H.Shala defense has no objection to the guidelines on witness familiarization adopted by the panel in case 04. So I thought I dealt with it sufficiently. If you want to say anything further.
Well, Your Honour, there is a difference between witness familiarisation with the Witness Protection Unit and witness preparation, as may have been proposed. Maybe I've misread that, but certainly that was a matter that we had addressed in the written submissions.
Yes, I've seen that, but what I understood was that you don't oppose, you favor the line adopted,
yes.
This panel, and it was my intention with this phrase I just read out to you to make the point that that was your position. So I think that we have dealt with it and we have taken note of your submissions.
I'm grateful for the clarification, Your Honour. Thank you.
Then I go to the defense for Mr. Bahtijari. Are there any issues you think we should discuss at this moment in time?
3 short issues. Firstly, the site visit. We are in communication. The issues have gone on for quite a long time, but I think we're much closer than we were before. So I'm confident that can be resolved as well. So we'll take the applause. Thank you very much. Secondly, we would like the opportunity to make more detailed submissions on witness preparation aside from familiarisation, and to make those in writing with the appropriate authorities and cases to assist the court. That would be our preferred approach if the court would welcome further written submissions. Our submissions at the moment in the documents for this hearing will you excuse me, were somewhat short, and we don't believe we've provided you with everything that you would need. So I understand what you've just expressed to counsel for Mr. H.Shala, but that would now be our preferred position, that you timetable some submissions on the question of preparation, not least because it's inextricably linked to the question of whether or not the prosecution documents are admissible. The prosecution is seeking to rely on documents that it's likely that they would put to the witness in preparation. So it's our submission that probably the best way to do things would be, when the prosecution make their submissions about admissibility in their motions, that should include preparation, because if certain documents are excluded, in our submission they should not be put to the witness before the witness gives evidence. So that's our submission, is that the question of witness preparation should be included in the motions and the responses that relate to the exclusion of those documents prepared by members of the Specialist Prosecutor's Office and their related operatives, I'll call it that. The third issue relates to medical. I'm not going to say anything that needs make us go into private session. I'm only going to say it in this short way, that we have seen a strictly confidential decision, and the consequence of that is we will try somehow to obtain some medical evidence ourselves, and if that's possible, I'm just giving, if it's appropriate for me to give the court notice, or at least I'll adopt the prosecution word of flagging. That may take a little bit longer than the 2nd of November. We will do our best to achieve that by the 2nd of November, but it may take a little longer, and we'll keep the court updated on that progress, the needs for approval and so forth. So I don't want to go into detail in public session, but we will do our best to obtain that ourselves and obtain it as quickly as possible. We have identified someone. There will be a question as to cost and availability. Those are the 3 matters that we would wish to mention now. Thank you.
Thank you, Defence Counsel, for Mr. Bahtijari. We take note of what you just said regarding the site visits, regarding the witness preparation. What I do understand is in our trial preparation decision, we mentioned familiarization. And And now I understand better why the defense wishes to make any further observations on preparation. We will look into that, and if we consider it necessary, then we will give you some additional time to express your views on that too.
Thank you.
And that also goes for defense counsel for Mr. H.Shala. Yeah? Good. Very well. Then it's the turn for the defense counsel for Mr. Januzi. Specialist counsel, you have the floor.
Thank you, Your Honour. I take the same position in relation to issues on familiarisation as those raised by Ms. Gerry and Mr. Cadman earlier. The only other matter that I'd wish to ask the court about is what the plan is for the rest of this week. And in particular, can I seek some clarification as to what the court wishes us to do about the proposal to sit on the 8th of November through to the 11th to the 15th? I understood that the court wants us to indicate our position as regards availability and the appropriateness of beginning opening statements and indeed the evidence during that period, and indicate that by time tomorrow. Does Your Honour wish that to be indicated by way of a filing, or is an email to the court officers sufficient?
Thank you. I think I've been clear. Tomorrow at 12, it's a confirmation of your availability. It's not an invitation. And secondly, yes, a filing is important to make because we want to have everything on record. And the problem is with emails that they are not on record. Huh? And so we also try to minimize. Sometimes it is necessary. But the less we do in emails, the more we serve the public interest. That's the only reason. And I do understand, Mr. Rees, that it is more cumbersome to make a filing than an email. But then it would just go into the dark holes of...
I understand, Your Honour. Thank you for the clarification. That was all I saw. Are we continuing to sit tomorrow and Wednesday as well?
Defense counsel, you're getting ahead because, of course, this panel would indicate what the schedule is. You must trust me on that. So, very well. All parties and the registry have indicated that for now that there's nothing else to discuss with the panel. So that means that for today, I will adjourn and we will meet again tomorrow at 11:30. So for the last session, we will prepare any oral orders that need to be prepared, directions given, and then after the oral orders we will indicate what the decisions will be, which decisions this panel intends to further issue in the upcoming weeks, so that's clear for you. And no, I said 11:30, but that's not a good idea. We will meet at 2 o'clock. 2 o'clock, sorry for that. 2 o'clock. And I think yes, tomorrow, 2 o'clock, we will give our oral orders. We will indicate what decisions we will be issuing. And then we are to close in that moment the trial preparation conference. And so for now, we have been very efficient, I must say, this morning. Thank you for your collaboration. I thank the parties, I thank the registry for their attendance, I thank the interpreters and our stenographer, and the audiovisual technicians and our security personnel for their assistance. And also, again, I'm I'm very pleased for this inter partes positive spirit in which all teams and the SPO is trying to make this proceedings go forward. Okay. The hearing is adjourned.
All rise.